and welcome to MediaNama. An interesting judgment has popped up in the gig space, wherein the Karnataka High Court has fined ride-hailing firm Ola Cabs as much as 5.5 lakh rupees for failing to adhere to PoSH obligations. The case specifically investigated two interesting aspects of the gig space. One was whether gig drivers can be considered as employees, and the second was whether something like a cab can be considered a workplace. And interestingly, as it turns out, the court's answer to both of these questions is yes. Not only did the Karnataka High Court acknowledge the gig workers as employees and cabs and as workplaces, it also dismissed Ola's claim that it only serves as an intermediary. Now, obviously, what you also may understand to be interesting about this judgment is the huge impact it can have in the gig economy that is currently undergoing a complete legal upheaval, at least in India. For example, there are different rules coming out in different regions, be it in Karnataka or in Rajasthan or even the entirety of India, where people are making different policies regarding welfare boards, regarding gig workers and their rights, or social security codes, etc. And another important aspect to consider here is the nature of POSH itself and what the judgment means for women gig workers in India. So, to discuss the implications in all of these spaces, we have with us today Anita Gurumurthy, the founding member and executive director of IT for Change. Anita, jumping right into it, we saw that the Karnataka High Court has called the gig workers, at least in this case, in case of POSH, not just gig workers, but also recognize them as employees. Now, this take is interesting because a few months ago, we remember there was the draft Karnataka gig workers bill as well, where the government had sort of taken an employer employee approach to the bill. And the feedback from the companies that we had received was that they were not happy with this approach because they said that the gig economy works different from an employer employee relationship. So, according to you, now that this judgment has come out, what kind of impact do you think it's going to have on the entire gig conversation that is going on in the state right now?
A very important and complex issue. Um, I think the question of impact on the rights of gig workers, also the rights of consumers, is very, very wide open. That question we cannot address very easily because we live in a society where we unfortunately tend to condone extremely barbaric and gross violations on women and women's bodies very easily. So what will really happen in terms of a public outcry, if a public outcry will happen, as we saw in the tragic case of the Kolkata victim? All of these are very, very open questions. I'm not very sure also, given the market power of these ride-hailing companies, duopoly in our case, it's easy really for consumers to have a reasonably good alternative. So that said, I think we must examine the merit of what has really happened in the Karnataka High Court. What's useful to understand is that the status of platforms, ride-hailing platforms as employers, is of course out there as an open question. IFAT has a case in the Supreme Court, and that case is yet to be heard. But of course, all platforms negate this kind of construction. They deny that they really have responsibilities as employers. Fortunately for us, this seems to be an open and shut case in the views of, let's say, the European Union's market, where the Platform Workers Directive has really stated unequivocally that there is an employer-employee relationship, right? And it may not be quite in the same way as traditional employment, but of course, the platform exercises considerable control, managerial control over the worker, and therefore the platform should be considered. The aggregator should be considered an employer. The second thing is that earlier this year, the International Labour Organization came up with its own white paper, its position paper, which is very, very important because next year at the ILO is the tripartite meeting on platform regulation and what are the rights of platform workers. And the ILO's own position is, let's really not, do this hair splitting about whether aggregators are employers or not. What we need to do is to start giving workers, gig workers, guarantees. And we don't necessarily need to wait till we have the proof of employment status. So this is really, I think, vital for us to understand that there is complete consensus in all quarters that gig workers have rights. Secondly, the consensus that these rights have to be guaranteed in the law. Therefore, by extension, I would say, and I also want to come to a different point which cannot be ignored, and that's the historical context of PoSH, Prevention of Sexual Harassment at Workplace, the law. That I think is a very vital piece in the Karnataka judgment, because we're not only talking about whether the gig worker is an employee and whether the employer of the gig workers has liability. That's a very important question. But we are also here concerned with the idea of what is a workplace. And maybe I'm anticipating your questions, but I think this is the way, my thought process is working. So maybe I can pause here. I don't know if I've answered your question, but I just wanted to say a little bit about the whole context of the workplace and talk a little bit about PoSH. Should I go ahead?
You can actually go ahead, because it was also interesting for the judgment to call the cab itself a workplace area. So, yeah, please do go ahead.
Yes. So I think that in the context of PoSH, which really tries to look at the unique context of informality in work and the fact that women and female workers are often in workplaces that are in the private domain as house helps, or they may be, working in very enclosed spaces like hostels or, any other. The whole idea was to broaden the definition of what constitutes a workplace. And this was much needed. The Vishaka guidelines later became the law, as you know. And therefore, the definition really hits at the heart of the beast of patriarchy. It really says that let's really not get too technical about what is an industrial context of a workplace. We know that women work in the fields, women work in homes. So the context of their public participation in the labor force depends very much on ensuring safety in all these spaces. So any private sector organization or a private venture or an enterprise that is registered as an non-profit organization or a service provider, which is of course what we are talking about in the case of the aggregator, is very much included within the ambit of the law. And this would include ideas of financial activities, including production, supply, sale, distribution, service, anything. And therefore, I think it's important that also within the law, the recognition of the unorganized sector, although the PoSH doesn't have an updation for the context of platform work, it does recognize the unorganized sector in relation to workplace, the kind of congruences of the reality of workers in the informal or unorganized sector, and the whole formalism of a workplace, which really says that service of any kind whatsoever really brings upon the venture certain duties, certain obligations, and therefore workers' rights become paramount, and therefore the rights of women become paramount.
Then, in that context, do you feel that this decision of the court to say that they are employees and that this is a workplace, do you feel that it's just only in context of PoSH? Would you call this decision an anomaly?
So the other thing about PoSH, we have to remember, and in the case of the victim or the petitioner, here the entire idea is there is a consumer and then there is a driver. So what does PoSH do in terms of the obligations of Ola in this case? It's not really, we're not defending the driver in this instance, right? Because he's the perpetrator of the crime. What we are saying is PoSH makes it incumbent upon any institution that has responsibilities towards, the safety of women, the task of ensuring that safety, which means that in that workplace, even if your employee acts against the interests of somebody else, probably somebody who's visited, in the context of a conference, if somebody is attending that conference, then you will have to take it up, which is why the judge referred to the internal complaints committee and said that the ICC had every duty to take this up. I would completely concur with that, because we cannot really get very cute with respect to legalities, and try to establish legal technicalities in order to evade obligation and responsibility. And in the context of PoSH, I think the prior right of women to have a safe ride is very important. The second is that the cab is indeed the workplace, because the cab is part of the algorithmic ecosystem of the platform, and the consumer in this instance wouldn't have booked the cab but for the fact that she has the assurance that the platform is providing the conditions that will make for a safe ride. So that is a prior contract with the consumer, and the conduct of the driver in this instance certainly is a vicarious liability that the platform carries. And vicarious liability is a very contested issue, but it's also an open and shut case in this instance, because the platform knows everything about the driver. It knows the ratings, it knows where the driver is going, coming, what the everyday rhythm of the driver is. And therefore, I think that with so much knowledge and control over the driver's actions, the platform certainly has a duty and a liability to ensure that the taxi or the cab is a safe space for the riders.
Right. So in this case, we are just looking. The case was just looking at cab aggregators. Now, of course, there are other services that other platforms provide. Like there's urban company that provides services where the person comes at home and gives you the service that you have asked for. So just considering how the judgment has gone, what kind of changes, or at least how would you recommend platforms to consider their operational model now that even courts are saying that this is a workplace and these are employees?
Right. So, fortunately for us, I think that there is precedent. And one of these things is that in 2021, I found this food delivery aggregator faced a lawsuit under PoSH Act. And here, the Internal Complaint Committee found that the company failed to provide a safe and harassment-free environment for its customers and the delivery executive, and therefore was held liable for payment of compensation to the aggrieved person. So one of the things is that if fines can be levied, there is actually not just for the Karnataka case, where I think the judge has kind of taken a very radical position to go as far as saying that, let's not really quibble over the employment status. Obviously, there is an obligation. Similarly, I think in February 2023, a notice was issued to Dunzo by Delhi Consumers Dispute Redressal Commission. Again, and here, this was seeking about 50 lakhs for negligent hiring. So what are the checks that need to be done? And of course, gig workers are also largely oppressed, and we shouldn't forget that. But the fact of the matter is, companies seldom provide the necessary training, the necessary inspection of the taxi, the ability for women riders, or in any context, as you rightly point out, in the event of food delivery, to be able to feel safe, to have the assurance that the delivery person or the driver in this instance has had some kind of training, because we cannot essentialize patriarchy. We also need to understand that we live in a society where behavioral conduct is part of the ways by which, in workplaces and at homes and everywhere, we need awareness. And I think at minimum, that kind of awareness about the law needs to be provided formally uh, to employees. And I would say employees, because we should consider that aggregators have a duty in what they call these contracting arrangements.
So just to push this conversation a bit forward, um, now, like I mentioned, that even when the bill had come out, the companies had said that no, there is a distinction between what gig work is and what an employment situation is. You mentioned some international forums that recognize gig work as employment itself. So how should a person go about drawing a distinction between gig and employment as we know it in everyday life?
In the changing world of platform-based labor, we actually see an increasing privatization of contracts. So the old idea of a workplace where everybody congregated, that is going away. And the normal today is really a virtual work, hybrid work, and the workplace itself is undergoing revolutionary change. And to be able to recognize the online as workplace is also another struggle fight for many platform workers. For instance, if you are in a global value chains where you provide, let's say, AI-based work, which is to label images, then what are your rights? Because you're in these transnational value chains and you may be employed by Amazon Mechanical Turk, and you might actually be in the Philippines or in India and you really don't know who your employer is. But all you know is you have an identity or an ID as an AMT worker, and you get into these spaces and you perform your tasks and you're paid by your tasks. It's vital to recognize that in these environments, you could actually be even sexually exploited, right? So that's the case even for people, and we've had newspaper reports around these things of teachers on online edtech platforms being harassed, or doctors on certain online service provider platforms being harassed, female doctors being harassed. So what we actually see is that the reality is not waiting for you to resolve these cases in the court as to who really bears the liability or has an obligation. The reality is that workplaces are changing and the nature of workplaces is changing. Therefore, I would really say that um, the idea of the gig, which is the performance of a task, which is associated with somebody on whom you have dependence, is very, very key to any contract. Aggregators wield considerable managerial power to allocate work, power to penalize, power to reward, power to rate, rank, and all of these are part of traditional labor law in which employer-employee relationships manifest. In the case of aggregators or in the case of platform employers, it's evident that all these parameters of what constitutes control over the labor time of individuals are all ticked in the checkboxes. And therefore, I think without necessarily fetishizing over, the legality of all of these things, we need to move the bar, and the nature of rights of people, whether they are actually workers for these aggregator companies or their clients employed by these so-called contractors, this entire ecosystem requires a revisiting so that we can ensure that the most powerful actor in the equation, which is the aggregator company, can take on its necessary responsibility and its logical accountability.
Right. But again, just to push this forward, gig as a system, as people had known it before or during the pandemic, say, a big appealing point for workers at that time was that there was no set criteria as such for becoming a gig worker. You just had to have say, for cabs, for example, you had to have a vehicle. And you also had the liberty to both work for aggregator A and aggregator B. Now, if we go for regularization, there is a chance that this metric will change. So, are we sure that the idea of regularizing gig work also goes to the benefit of the workers?
Yes, of course. I think that um, to argue that compliance places burdens which then become barriers in the economy is a very short-sighted view, because in the medium to long term, the predictabilities of these arrangements actually creates a more trustworthy economy. Because in the economy, I think you need predictability. We all need to know that rights, duties, obligations, liabilities are clearly distributed. Ambiguity is not helpful for anybody. And I would say that yes, the aggregators may be providing job opportunities, and labor is extremely important. And therefore, there will be a certain way by which, we need to look at these aggregators as job providers. But it's equally true that there is no benefit, and there are studies after studies which talk about working conditions, which is a completely different story from what we're talking about now. Those I think are not tenable. I mean, they are really going to cause immense harm to the way in which the economy functions, the way in which precarity really gets entrenched. And therefore, I think a rights-based environment in which the rules are very clear. And here we really have to not only look at PoSH, I mean, even the Motor Vehicles Act, those guidelines prescribe that PoSH is included in its ambit. So I really think that we, by constantly, this is like a red herring. Aggregators will say, let's resolve the definitional question of whether we are employers. But that red herring has to be displaced in favor of, I think, a rational argument as to, are people, whether they are workers or whether they are consumers, are they deserving of rights, right? And in that case, who is to be held responsible? How do we share liability? Because if the platform has some liability, obviously a heinous crime by a driver would also place upon the driver, the liability. And of course, in the instance that companies, which have vicarious liability, go to law enforcement authorities and say, we've had this episode, this is the driver is going to be penalized under the criminal law. But the fact of actual knowledge of such an occurrence on its platform is something that the intermediary is bound by law to report. And therefore, I think that ignoring sexual harassment is simply, another means to really belittle the hard-fought rights of women in society. And so economic arguments and these webbed arguments, which is really like, a dog chasing its tail, will never enable society to move forward, whether for labor rights or for women's rights.
We are just talking about Karnataka right now, but looking at India in general, is India's approach to the gig economy very different from the international forum, or from compared to any other foreign country, or are they also looking towards gig like an employment situation?
Um, I'm not very sure, because jurisdictions we normally look at are European jurisdictions, because we're drawing inspiration from, a social contract that is somewhat better. We are looking at idealized conditions. We don't look at the US because there exists no social contract. We know the story of California, and the idea that, let's say, in certain countries in Latin America, we've actually had some positive movements, um, is important. I would also say that a couple of years ago, we studied in my organization the context of South Africa, and we found that courts were not uniformly in favor of workers, but these were early days. What I can say is that the discourse about gig workers' rights is moving the right direction in India, because I do see like a lot of public sympathy, questions about caste, community, all of these are raised. And certainly, for instance, accident insurance, industrial disputes, all of these are actually becoming real issues. However, I do think that this context of unemployment, the realities of lack of employment generation in rural areas, which then places burdens on cities in India, All of these mean that the gig is here to stay. So the question is, how are policymakers going to take this question up as an important political issue, not just an economic issue, but an important political issue, which is, I think, their mandate, right? I mean, so I feel that not enough has happened. The Rajasthan Act has not necessarily made way for better living conditions, better working conditions, decent work for gig workers. In Karnataka, the bill, which actually conceives of PoSH, actually, the Karnataka bill does include reference to sexual harassment and clearly and squarely, tries to pin down the responsibility on the aggregator. These are encouraging developments, and I would also say that these various consumer court cases, but I think they have to be read alongside traditional cases where, I have a couple of examples here in what may be landmark cases where the Vishaka guidelines and the PoSH Act have been asserted, and the responsibility and liability of principal employers called out, and vicarious liability enunciated. These cases, one is Farah Diba versus National Capital Territory of Delhi. The other is Medha Kotwal Lele and Union of India. Another case is Saurabh Kumar Malik versus Comptroller and Auditor General of India. In these cases, the responsibility to prevent sexual harassment has been called out and responsibility is fixed. And I don't think that much inspiration can be drawn, particularly for the safety, security, and labor conditions of female workforce in the gig and platform economy. And also, I think largely, the conditions of gig workers, which includes, I think, the ability to perform work in ways that can be decent and where guarantees for decent work exist.
As a last question, I would split my last question into two bits. One is, what do you think that companies should look as takeaway from this judgment if they're going to go back to their operational models and take a look at it? And how should policymakers understand, and what's the takeaway that policymakers should have from this judgment when looking at things like, say, the social security code that is there on the central level and on certain state levels, but implementation, as we know, is up in the air right now.
So to take the second question first, I think implementation or enforcement of anything really requires political will and the processes and mechanisms that are in place to ensure that something happens. So that's the same with let's say, the Lokayukta, right? Anti-corruption bureaus. Like, we have to ensure the independence of these authorities, and we also have to make sure that we are able to bell the cat. And to that extent, the lobbying power of many of these companies really, puts to some kind of doubt, the ability that radical judgments, which are pro people, pro workers, have the capacity or the potential of these judgments to be able to, trigger positive change. So I think the implementation question is also tied very deeply to the deep pockets and the lobbying power of these companies, which brings me to the first point. We are going to see a time where the noose will tighten around the necks of all these companies. And that's because there will be global pressures. And at subnational levels, when we see positive change in a couple of states and the ability of certain states to be able to, at least bring in a modicum of enforcement, we are going to see some positive changes. The good thing also is that with supply chains, it's also going to be increasingly possible with the EU directive, Platform Workers Directive, for international companies like Uber to be brought to book. Because technically, it's possible for a trade union to take a case to Amsterdam and say, in this supply chain, you're responsible. So I feel that much depends on the way workers unite, and it also depends very much on how consumers are able to popularize and bring strengths to ethical questions in the gig economy. So that's actually where it is. I just read today morning about a case in Victoria in Australia, in this province, where it was possible for public sector workers to actually prevent private companies from coming in and taking away and privatizing data on birth registration, marriage, etc. So the union argued that this data really had to be secured in public ways, and it's really not possible to privatize this. So I would actually say that the way platform companies are coming under scrutiny, and also the vigilance of consumers and workers is a good thing.
No, but specifically looking at the judgment, what takeaways would you say companies and policymakers should have?
Um, I think that safety requirements cannot be compromised in the gig workplace. And companies must come to terms with the fact that the extension of their activities, whether it is, in mobile units like taxis or in terms of service provisioning through a matchmaking on an app for deep cleaning, all of these create a certain liability, because as economic actors who are fixing the market in certain ways through their algorithmic control, they need to, accept that they have certain duties. So these duties are prior to when harms happen or, damages happen. And therefore, coming to terms with responsible conduct with their duties is paramount. Policymakers really need to understand from this judgment that they need to hasten and look to the ways in which sectoral regulation, just like the motor vehicles guidelines, or larger gig workers guarantees, labor guarantees for decent work, that there be movement on these matters. So we don't necessarily have to wait for central government regulation. We should actually, states should take a leaf out of the Karnataka High Court judgment and move on these things so that we actually see a dynamic on the ground.
All right. Thank you, Anita, for speaking with us. And thank you for everyone for listening to us. For more things on tech policy and the gig economy, do follow Media Now.